Afternoon, Your Honor. Michael Gaddy, Assistant Public Defender, on behalf of Mr. Mishka, who I'm looking for on the feed. There he is. State your name, sir.
What starts as a routine courtroom check-in quickly spirals into something far more serious, and you can already feel the tension building before a single major accusation is even confirmed. We're looking at a defendant, Mr. Mishka, appearing remotely, represented by a public defender. And initially, everything seems procedural, almost calm. But beneath that calm is a ticking clock. There's already mention of sobriety court eligibility, which signals prior substance-related concerns, and immediately after that, the narrative starts layering complications. A warrant in another county, missed court appearances, and questions about compliance. Now here's where things get interesting, because in cases like this, consistency is everything. Judges like Judge Simpson are not just listening to what's said. They're watching behavior, tone, and credibility from the very first moment. And when a defendant starts off with unresolved warrants and unclear compliance history, the margin for error shrinks fast. Pay attention to how quickly the tone shifts from procedural to investigative. This is no longer just about scheduling, it's about accountability. And the big question already forming is this: is Mr. Mishka genuinely trying to comply, or is he already digging himself into a deeper hole without realizing it?
Where'd you see him? Is he on there? No.
Wearing a green shirt.
Yeah, he's wearing green. He's wearing green. Probably the only one wearing green today, Judge.
Oh, there he is. Okay.
Hey, how are you, Judge? Happy St. Patty's Day.
And to you, sir. All
Thank
right.
you.
I got it. All right. What are we doing on this case, folks?
Your Honor, in this matter, we've been talking about potential sobriety court. I have sent an email to the sobriety court team at 15th District Court today, and hoping to find out if he's eligible. I'd ask the court to adjourn this matter maybe 2 weeks so that I can get that done. I will endeavor to get it done as soon as possible, and get Mr. Mishka through their screening process. I have had a chance to speak with Ms. Landy, and she has informed me that there is a warrant for Mr. Mishka out of Livingston County that I've addressed with him.
Your Honor, my notes indicate, looks like the last time that we were here on the 24th, we had a warrant at that time. So I'm not sure how he's out of custody, but can the court confirm that he is testing? Because that was an issue before our last hearing.
I had court, Mike, last time. That was why. Remember?
I wasn't your attorney last time.
Well, on the 24th, I had court that day in Livingston County, and I had talked to, I forgot who, with your office over there, Your Honor, and they set up today's court date due to that missing that court date, because Livingston scheduled the same time as you, or your court date.
Your Honor, it's
last time on February 24th, I issued a bench warrant for his failure to appear, issued it immediately. Typically with that, there is then no court date set. The defendant then came in and requested that be reset. So we reset his case, his bond, with all of the conditions reinstated. And then, so we recalled the warrant, and then we set this date.
And Your Honor, in that case, the last time he was before Your Honor, I believe was February the 3rd. And since February the 3rd, there have been 3 obstruction events confirmed by house arrest services, as well as TAC's alcohol being detected through the...
Hold on.
This is the moment where the case takes a sharp turn, and it's not subtle. The prosecution introduces concrete violations, obstruction events, and alcohol detection. That's not speculation. That's data-backed monitoring, likely from a scram tether system designed specifically to track alcohol consumption. Now here's the legal weight behind this. When a defendant is on bond with conditions like sobriety monitoring, any violation isn't just a slip-up, it's a direct breach of the court's trust. And courts take that extremely seriously because bond is essentially a privilege, not a right. But what makes this moment even more intense is the defendant's immediate reaction. He jumps in, insists he hasn't been drinking, and tries to defend himself in real time. That's a critical mistake. In court, especially under scrutiny, Unsolicited explanations can do more harm than good because they're not filtered through legal strategy, and now you've got conflicting narratives. The system says alcohol was detected. The defendant says he's clean and doing everything right. So now the question shifts from compliance to credibility. Who do you believe here? The data or the defendant?
Since February 3rd,
Yes, Your Honor. February 9th, February 10th, February 12th. Do you have the,
I do. I see what they did.
Can I say something, Your Honor, Mike? I've been on this tether for a while, Mike, and I've been doing 6.
Sir, let me do the talking, okay?
Yeah, no, all right, no problem. I just saying I've been tested 6 times a month for Livingston County, ETGs, full scale. I have not been drinking. I got the tether on and everything.
I'm just pulling up the bond violation right now, Your Honor, if you'll give me a sec.
I got February 9th at 6:19. February 10th at 8:14 p.m. They're all p.m. And then at 10 p.m. on the 12th.
These are February?
Yes, sir.
No, I know I haven't been drinking. I've never felt so good in my life, Your Honor. I mean, I have the tether. I got Livingston County.
This is one of the most revealing moments in the entire hearing, not because of what's proven, but because of how it's presented. The defendant is emotionally leaning into his defense, emphasizing how good he feels, how compliant he's been, and how he's actively testing elsewhere. But here's the disconnect. Feeling good is not legal evidence. Courts operate on documentation, reports, and verified data, not personal testimony about well-being. And notice something else. His attorney is repeatedly trying to control the situation, telling him to stay quiet. That's not random. That's strategy. Because every extra word the defendant speaks without guidance increases the risk of contradiction. From a legal standpoint, this is where things start slipping. Judges don't just evaluate facts, they evaluate discipline. And when a defendant can't follow even basic courtroom instructions like stop talking, it signals something deeper, a lack of control under pressure. So now the issue isn't just alcohol or tether violations anymore. It's behavior, it's composure, it's credibility under stress.
I'm doing everything.
I'm not going to be able to stop you from talking.
I know, Mike, I'm sorry. I'm just nervous. I'll shut up.
and Your Honor, it's also my understanding there's a note now I see in the file from Mr. Danner that Dorian Harrow, the probation officer for defendant, that the defendant is in violation status in Livingston County, was arrested on March 3rd, 2022 in Oakland County on an OWI, and they're awaiting blood results.
I wasn't? What the hell?
You're saying he was arrested when?
Pulling up the correspondence that Mr. Danner received from the probation officer, and I'm happy to forward this to the court if we want to pass it. But it's my understanding he was arrested March 3rd.
I was not.
Well, sir, here's the thing.
Yes, Your Honor, I'm listening. Sorry.
Just so that you understand,
Yes, sir.
your attorney has told you to be quiet. I joined with your attorney that you should be quiet,
Yes, sir.
not say anything.
This is a critical power moment from Judge Simpson, and it tells you exactly how the court is interpreting everything happening so far. The judge isn't just correcting behavior, he's issuing a warning with consequences attached. When a judge explicitly says, "I will make you the guest of the county jail," that's not casual language. That's a direct signal that custody is now on the table. Here's the deeper legal reality. When a defendant continues speaking after both their attorney and the judge tell them to stop, it creates the impression of defiance, even if that's not the intention. And in a courtroom, perception can heavily influence outcome. The judge also makes something very clear. He listens to everything. That means contradictions, tone shifts, and inconsistencies are all being mentally logged in real time. At this point, the courtroom dynamic has fully shifted. This is no longer about verifying facts. This is about whether the defendant can be trusted at all.
You're continuing to say something. There's now evidence being presented to me that there may be other incidents. I'm going to suggest very strongly that you be quiet.
I will.
I'm also going to indicate so that you're clear as to exactly how I work.
Yes, sir.
I hear everything anybody is saying. So if you're telling me that it's not the case, but I determine even on a preliminary basis that I believe it to be the case,
Mhm.
I will make you the guest of the Washtenaw County Jail. So
Right.
it's going to behoove you at this point to be quiet.
I'm throwing away. I'm done. Sorry, sir.
Court will pass this matter.
Thank you, Your Honor.
Sorry, Mike. All this was new to me. So,
Just mute your,
And again, you should be quiet.
oh, I'm sorry. I thought I was out.
Yeah, I know. Court does call the case, recalls the case, People versus Miska.
Ashley Lundy for the people.
Mike Gaddy, Assistant Public Defender on behalf of Mr. Mishka, Your Honor. Mr. Mishka is on Zoom. He's Mr. Mishka, just mute yourself and state your name only.
He's there.
Yes, I see him. He's outside.
Matthew Luke Mishka. Can you hear me now? Matthew Luke Mishka.
Your Honor, I forwarded the court the correspondence we received from the defendant's probation officer regarding the Oakland County arrest. I also printed out what I was able to get from VineLink, which shows the record of his arrest on March the 3rd in Oakland County and a release on March the 4th. It also has a color mugshot. We're showing a individual, I believe, that bears a resemblance to the defendant with the same name. So I do believe he was arrested in Oakland County on March the 3rd, like I stated, and I did communicate with Mr. Gaddy, who also confirmed his warrant in Livingston County. So at this time, he's got tampering with his scram tether, a warrant in Livingston County, and was arrested in Oakland County on March 3rd. So I'm requesting that his bond be revoked and he be remanded to the custody of the Washtenaw County Jail. Thank you.
Now the situation escalates significantly. What we're hearing here is a stacking of violations across multiple jurisdictions: tether tampering, a warrant in another county, and a confirmed arrest record. In legal terms, this is what's known as compounding risk factors. Each individual issue might be manageable on its own, but together they create a pattern, and courts don't ignore patterns. The prosecution is building a narrative: non-compliance, possible deception, repeated legal trouble across counties. And once that narrative takes hold, the burden shifts heavily onto the defense to disprove it. Now ask yourself this: at what point does the court stop giving chances and start enforcing consequences? Because we're getting very close to that line right now.
Your Honor, if I could, it's my understanding that he does have a matter in Livingston County. And in terms of the tether violations alleged here, they're for blockages except for the 2 in February. But Mr. Mishka has been testing at DNA at a place called DNA Services in Howell 6 times a month, doing full panels as well as ETGs. So I would think that if we could obtain those results, it would be would clear up that in terms of any usage tether. In terms of the March 3rd event, it's my understanding that Mr. Mishka was not arrested there, and that it was a person named Veda Oro. I have not been able to confirm this one way or the other, but that's I've just found that out. I've just found out about the Livingston County issue this morning. I'd ask the court to set this over. I'd also ask the court to set this violation over as well. See if we can't get those results and share them so that we can determine. The real issue here is usage, and so if we can determine what's been going on, it's my understanding he has been on the testing in Livingston County, which is a non-alcohol related matter, I believe, but he's been on it since last July. Or August 1st. I can't remember if it's July 1st or August 1st, no, Judge. Of 21.
Here's my, I guess here's going to be my issue is I'm looking at the email from Mr. Harrow. Outside, and I'll set aside for the moment the arrest on the 3rd. He's currently in violation of his status on probation in Livingston County.
This is where Judge Simpson begins laying out his reasoning, and it's methodical. He's not reacting emotionally. He's analyzing evidence step by step. Notice how he breaks it down. Violation status in another county, mugshot resemblance, matching date of birth, fingerprint confirmation likelihood. What he's doing here is dismantling the defense's uncertainty argument. The defense is suggesting confusion. Maybe it's not him. Maybe records are unclear. But the judge is essentially saying, for all of this to be wrong, it would require an extremely unlikely chain of errors. And courts don't operate on unlikely scenarios. They operate on probability and evidence. This is the turning point where the judge mentally shifts from let's verify to this is likely true.
The other thing is that as I'm looking at the violent photo, if that's not him, then I would be absolutely shocked. I would also be shocked by virtue of the fact that when, although it's blanked out on here, this individual that was arrested would have to have the same date of birth as the defendant does according to our records. I would also find it interesting that they would then report after receiving fingerprints that this is this individual and not someone else, or that the fingerprints came back to somebody else. So I find all of that would have to be a remarkable set of circumstances to happen for this not to be the defendant. The other thing is that his probation agent is also speaking to him regarding it. So he's got violations up there. He's got potential violations here. There's also the potential of an arrest that occurred in another county. So that's what the court sees. Mr. Gaddy, your client, I believe, wants to speak.
Mr. Miska, just keep in mind anything you say can be used against you, and I don't know what you're going to say.
I was not arrested. I did not give blood, but I was taken to jail and held because of the warrant by Livingston County and released the next day. I just wanted to clarify that.
Okay, okay, Mr. Miska, you're making this worse for yourself because the arrest is for an OW. Hold on. The arrest is for an OWI.
This is the collapse moment. The defendant is now contradicting himself in real time, and Judge Simpson catches it immediately. First, I wasn't arrested. Then, I was taken to jail. That inconsistency is devastating in a courtroom setting, because once a judge perceives that a defendant is being dishonest or even just inconsistent, it erodes all credibility moving forward. And listen to the judge's tone shift. He goes from controlled to openly frustrated, even calling out what he perceives as playing games. This is no longer about evidence. This is about trust. And once trust is gone in a courtroom, outcomes change fast.
As I told you prior to the break and passing your case, I remember everything that everybody says to me. Now, if you want me to go back and play it, you first of all indicated you weren't arrested.
Well, I wasn't driving.
Whoa. You indicated you weren't arrested. Now you're telling me you were arrested. Now you give
Well, I
me,
think the
this is
charge.
why, you know what?
I'm sorry. I don't want to say.
I am so done. I think
I can't- you're breaking up. I can't hear you.
I think you're playing games, and you're not going to talk your way out of it. Not with me.
I don't want to try to
So
talk.
here's where we're going to go.
Yes,
I
sir.
will adjourn this out. In fact, I'm only going to adjourn it out 1 week because of what I'm about to do. So I'm only going to adjourn it to March 24th,
Okay.
2022 at 9 a.m. I am at this time, based upon what the court sees before it, I'm revoking the defendant's bond in this case. Defendant is ordered to report to the Washington County Jail. Sir, you are ordered to report by 3 p.m. today. Your failure to report, and I want a direct report, Scotty, at 3 if he's not there. If you're not at the Washington County Jail at 3 p.m., and you can try me if you want. You can ask any other defendant that's appeared before me that's wanted to try me on this. If you're not there, I'm issuing a bench warrant for your arrest. You'll be held without bond.
Okay. I'll be there today. What do you? What am I
So
reporting?
we will come and get you if you're not here at 3 p.m. at door R4.
Okay.
You better be down at that door.
Okay. And what? And does that have to turn myself in, sir?
Yes, it is.
I wasn't trying to talk my way out of it, sir. It was a lot of stuff coming at me, sir. I'm doing the right things. I mean, I did have police contact. I just wanted to let you know
Mr.
that.
Mishka, the judge has ruled, sir.
Like I got to pick up my kid for school today. Like, oh my God.
Thank you. Okay.
And there it is, the final decision. Bond revoked. Immediate surrender ordered. This is the consequence of everything that built up throughout the hearing. Alleged violations, cross-county legal issues, contradictions in testimony, failure to follow courtroom instructions. From a legal standpoint, bond revocation happens when a judge determines that a defendant can no longer be trusted to comply with conditions or appear reliably in court. And in this case, Judge Simpson made it clear. The risk was too high. What's especially striking is how quickly this escalated. What began as a request for adjournment turned into a custody order within minutes. That's the power of courtroom dynamics. Every word, every reaction, every inconsistency matters. The broader takeaway? In the legal system, credibility is currency. And once it's spent, it's nearly impossible to recover in the same proceeding. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.